In Alison Healey versus Mr Daniel McGrath, the High Court apportioned liability and costs between Ramsay Healthcare UK Operations Limited and Mr Daniel McGrath, a consultant surgeon, following the death of a patient, Mr Simon Healey. The central issues were the extent of each defendant's responsibility for the negligence and whether Mr McGrath, the Part 20 defendant, should contribute to Ramsay's costs of defending the main claim, which Ramsay had settled with the deceased's widow. The court found Mr McGrath 75% liable for the damages and the claimant's costs, and exercised its discretion under Section 51 of the Senior Courts Act 1981 to order him to pay 1/3 of Ramsay's costs in the main action, considering factors such as his primary responsibility and unsatisfactory conduct in the proceedings. Quote, "On one view, Ramsay is 100% responsible for its own negligence. But I regard that as too simplistic a characterization in this case, and one that is unfair to Ramsay. Its nursing staff were heavily dependent on Mr McGrath's expertise, experience, and medical leadership. His negligence set in train a sequence of ultimately catastrophic events. I judge that it is just for Mr McGrath, in these specific circumstances, to make a contribution to Ramsay's costs. I find that the 75% contribution claimed is excessive and disproportionate. Mr Weitzman in his submissions realistically observes that the court may feel in its discretion appropriate to award a lesser proportion. It does. On what is before the court, I assess that the fair contribution to Ramsay's own main claim costs that Mr McGrath should pay is 1/3. For a detailed summary of this decision, visit tmclegal.co.uk.